Okay, we are live this morning and welcome everybody. It's the Senate Transportation Committee, Tuesday, January 25th, and we're trying to get through the miscellaneous bill from the Motor Vehicle Department. We have all the folks from DMV with us, and we've got to get this out. So we're trying to get all through the details this morning and probably vote it out tomorrow morning first thing. And so who wants to lead off this morning? Does it Wanda want to lead off? Is that the way it goes, or? Okay.
Yes, thank you,
Mike
Senator
Smith,
Mazza.
okay.
Yeah, and I have Captain, also with
right.
me, I have Captain Andrews.
Well, you surround
and
yourself with good
he'll
people.
protect me.
You surround yourself with good people. That's good news.
That's right. That's how a department's successful. So
okay, go right ahead. It's all yours.
So I know Anthea walked you through the miscellaneous bill, and as a result of that walkthrough, there were some specific questions and just wanting to understand some of the goals of the language that we proposed. And so I'm not going to bring up, unless the committee prefers, the miscellaneous bill, but if I could just talk about the key sections and address some of your questions that you asked. And does that make sense, Senator?
Go right ahead.
Okay. So the Department of Motor Vehicle, so the first item that I think is the largest item that we propose is modification or clarification to the total abstinence program. And we proposed language that allowed us to clarify in statute under the total abstinence program the definition that you have to abstain from alcohol and drugs, and that with the exception of your prescription that applies to total abstinence. So I think this committee will recall in 2017 you made a modification to include the use of prescription drugs as long as you're following it. And what has recently happened, and I'm trying to lay this out so I can sort of be clear. I think I'm going to go to your questions. So every person who enters the total abstinence program that chooses to do that, first of all, are individuals that have a lifetime suspension of their privilege to drive a vehicle. So it's 3 DUIs or more. And through the legislature, you created the total abstinence program that after 3 years of sobriety, going through counseling, working with your counselors, there's a very detailed application. You can choose to have the restriction, if you're using it, of an ignition interlock on your vehicle, but the privilege to get your driver's license back. And through this, you agree to sustain from all use of alcohol and drugs. And it's a very intense program, and the individuals that do apply, I want to share with the committee, they take their sobriety very, very, serious. And when you apply, the way the statute is written, you automatically get a hearing through the hearings division at DMV. Your application is approved. If you violate, or if we learn that you have not been compliant with your agreement, we have the right to revisit your agreement, and we can put the conditions back in place where you may have to use an ignition interlock. So the question was asked, are there any pending litigations relating to the total abstinence program? No, there currently is not any pending litigations. However, our hearings decision on a couple of individuals was challenged, and they took that to the courts. And what the court findings in the statute was that we have modified the statute so many times that there was no mechanism for the commissioner to really put you back into the program. And it's not in, it's just not there, and the language doesn't align. And if Matt, you could show the PowerPoint on the total abstinence program, I would really appreciate it. Just that one slide. So this is just the history of the total abstinence program that's been put in place by the legislature. And as I said, we understand, and the language to us is very, very clear that it's abstinence from alcohol and drugs. But as a result of our hearings being challenged, you can see that the creation in 81 to 1990 is that the only way you can be removed out of the program is if you have subsequent DUIs. And then you modified the language again, and that this was a violation of driving with any amount of alcohol in the system. And again, and then in 2004 to 2009, you only could be violated if you were above a 0.02. And this
that
is
was
for
to deal with a cough syrup, right?
You have we know it had to do with some level of BAC. I don't know if it was the cough drop, but I trust your memory, Senator.
I think it was. I think it was some kind of like cough medicine would trigger a violation of any amount of alcohol.
And then again, there was a model. We modified, or the language was modified. That consuming the substance that served as the underlying DUI, which was typically alcohol. And then in 2017, you added the clarification regarding prescription drugs. So this is the history of the TA program, but what is consistent is the Department of Motor Vehicle. You can take the slide down now, Matt, thank you. The Department of Motor Vehicle has been managing the program, its total abstinence as defined of any substance or combination of substance other than alcohol that affects the nervous system. And with the recent decisions, without bringing clarity that we've asked for, we are now going to be asked to manage a program under all of those statutes, under the 5 different categories, which is not total abstinence in effect. And the issue is not new individuals coming into the program, it is the individuals that had a lifetime suspension on their license. And that we are looking for clarification and support to have one TA program that is applicable to all. So when we talked about, I know you brought up the questioning, Senator Kitchell, on retroactive. We thought that it was best, if you look at the language and the effective dates, it is really retroactive in that. But working with the assistant AG that supports me, the better, the stronger the definition of what the intent is, the better off we are. And so we asked for the language of retroactive to be in there, but that's always been the intent. It is the intent now. It is how we manage the program, but we were just pointing that out.
So, Commissioner, I've been trying to think about this. It seems as though what we're saying is you came into the program different times with different rules. So yep. We aren't it seems to me your intent is to say, whenever you came into the program, whatever the rules at that time, they are being replaced with these clarified rules from this point forward. So yes, the retroactivity is it's more on the individual saying those rules aren't locked in perpetuity based on when you came into the program. So to me, it's a lot clearer to say any active participant in this program has to comply with these rules effective whenever we're making it effective. And
Correct.
And so I was struggling, what are you making retroactive? How can you make rules today retroactive to somebody who came in, you know, in 91? And then it seems to me what you're saying is we want to say everybody will have to meet these requirements effective whenever we change them, whatever the effective date of these clarifications are from this point forward. Whether you're coming in new after that date or whether you were participating in the program 5 years ago, 10 years ago, or whatever. Now,
Absolutely.
maybe I'm misunderstanding what you mean by retroactive, but I think the best way I understand it is how an individual who's currently active in the program will be treated.
Correct. And I think to add, I appreciate the thought that you've put into this, because today, based on the statute, the current statute, if someone violates their TA agreement, and the simplest way to explain this is that they have been stopped and they have been charged with DUI, another of the DUI, and they're currently in the program, we apply the statute that is today for how we manage it. So that means that we would remove them from the program. And so when we talk about, I'm just trying to connect with what, we're managing in the way that you just described. And that's how we've been operating the program as well. Is based on the 2017 language. We apply that now to every individual in the program.
Okay. So what you're saying is that, in fact, if we clarify and change these rules, then everybody will be subject to the new rules from this point forward.
Correct.
So what is being made retroactive? None of the rules themselves are retroactive. It's just saying we are, the only thing that is in the past is the participants who came in previous to the change of this statute, but are going to be subject to these requirements once they become effective.
What we're adding is the definition in that says that the total abstinence program means refraining from consuming any amount of alcohol or drugs defined in Title 23, 1200, regardless of whether one is consuming the substance when attempting to operating, or actually physically in control of the vehicle. So it's not just aligned with driving the vehicle, it's identifying that total abstinence is total abstinence and refraining from using alcohol and drugs.
Yeah. Okay, so I guess I just don't understand I understand you want to change the rules. I understand you want to clarify. I guess what you're saying is if you identified someone, evidence came to date that that behavior predated when these became effective, you would apply them anyway.
That has been that is how we have interpreted the language and how the program has been operating. And what the recent challenges that we faced is that every time the language was modified over those 5 different scenarios, is that there was no mechanism to for us to actually, we were applying the current statute, and we should have been going back to the time of the incident in which they violated. But when we look at the definition and we look at the program, it's our understanding, and we believe the intent of the legislature is that you refrain from use of all alcohol and consumption of any drugs, with the exception of your prescription, in order for us to give you the privilege to get your license back, because you are in the lifetime suspension of not being able to hold your license.
So the cases where where it says or drugs and they came in on alcohol, are you suggesting if we make this change, you could go retroactive on those cases and take action?
No. What it means is that if an individual that was entered the program in 2004, for example, and they have been stopped and charged and convicted of driving under the influence of a drug, that we can take them out of the program and put them back into using ignition interlock. So they'd still have the right to because the law is 3 or more DUIs, you can use an ignition interlock to continue having the privilege of driving. What the total abstinence program does is it identifies your sobriety and it removes that restriction, and we give you the privilege to drive without that restriction. And so, and to the program, again, we believe with the changes that the intent of the language is it's to be in the total abstinence program. No matter when you went into it, you must refrain from the use of alcohol and drugs.
Chairman Mazza.
Yes, go right ahead, Senator Chittenden.
So I think I'm struggling with a similar question, the line of questioning as Senator Kitchell. But if I could frame what I think I'm understanding here, that this is not retroactively changing the rules for when an incident might have occurred in 2012. What this is doing, if I'm not mistaken, is making it clear that the rules that were in effect at that time apply to when that incident is, while simultaneously, as of the passage of this, the rules are then the same for everybody, even if they were admitted into this program back in 2002 or 2007. So it's not retroactively changing the rules as of the time of the incident, but it is making it clear that going forward, the rules are the same for everybody in the program. Or am I missing this as well?
Well, that's what I wanted to say. I would interpret, and therefore I would not even deal with retroactive, because what you're saying is as of such a date, these are the rules and they've been updated and they apply. But I think Wanda is saying that's not what the intent is. So if someone violated this, because of the ambiguity about alcohol or drugs, then you could go back and sanction that person if it were 6 months before we made this effective, under the new rules. That's what I need to be clear on, because it's the very question that you're asking is what rules apply at the time the incident. Sometimes an incident might be identified prior to the implementation, before we change the statute, but only comes to the attention of the department after. So that's what I'm trying to clarify what we're doing here. So
what we are asking for, I guess, I want to just remove the addition that we asked where we put retrofit in the middle of some language. And what we are asking is that the changes that we put in place shall take retroactive effect upon passage and shall apply to all individuals currently participating in or in the process of applying for the TA program. So we are asking for one standard of all participants, no matter when they entered into the program. And that going forward, that their agreement is that they refrain from the use of consuming any alcohol or drugs as currently defined in Title 23, 1202.
Okay, so you could be going,
Yes.
you could be actually taking action based on current rules
Correct.
now. And I mean, that would be modified or amended by this language. So you could go all the way back to when we started the program.
And Senator Kitchell, that is how we've been running the program. If you were, entered into the total abstinence program in 2007, and you recently were charged with driving under the influence of drugs, even though drugs were not mentioned in 2004, not 2007, we managed the program and the individuals in the program to the current definition in statutes. We've never looked at the program or managed it under those 5 different scenarios, because we've understood the way the modifications in 2017, it didn't speak of retroactivity, but the department said to be in this program, it's that you are abstinent from the use of alcohol and drugs.
Yes, right ahead.
So that's clear to me, and that I think I can get behind. That makes sense. Standard set of rules for everybody in this program, regardless of when they came in from the data passage going forward. What's unclear to me and what I'm struggling with is with these changes, if 3 months ago or a year and a half ago, there was an incident for somebody in this program and they are contesting it. Will these changes change the rules for how they are contesting that incident that occurred before the date of passage of this bill?
So currently we have no one contesting. I just want to say to you, and that because of the decision from the courts, if we get reported that someone has, recently been stopped and charged with a DUI and prosecuted, I have directed my enforcement team that they have to look at the year in which they came into the program until we bring clarification through the legislature. So I'm saying to you, no one should be in that situation. Is it once the language passes, are all of a sudden we going to go back and look at the 1,200 people in the program and say, oh, you violated in 2009, now we're going to apply this new rule? No, that is not the intent. We're looking for a solid foundation to manage the total abstinence program for the residents of Vermont that can demonstrate their sobriety. Because again, I think it's important, and you all know this, these are individuals that have been habitual offenders, and these are individuals that have worked towards their sobriety and want the privilege to drive again. And they have to, and the application, I just want the committee to know, it's in partnership with IDAP, it's in partnership with their counselors. I mean, the individuals who do enter into this program take this very seriously, as we do, but we need to have a clear platform to work from and to manage the program.
Okay, how are we doing?
If I may ask one more follow-up, Chair Mauser?
Sure, go right ahead.
So I think I'm on the same page, but I didn't get a crystal clear response to my question there. Is the intent of this language to, let's say between now and passage, something comes up and there was an incident that occurred prior to its passage. Is the intent of this language to apply these new standard rules to everybody in the program to that incident that might have occurred before the rules are in effect. Is that your
Yes.
intent?
So I would say no. What we have to, if there is a violation before this change occurs, we have to look at the year in which the person entered the program. And that statute is applicable to the violation.
Well, then what's the retroactivity for?
Because prior to the decisions, we have been managing the program to the definition, as we understand the intent is consumption from alcohol and is to be abstinent from alcohol and drug. And the retroactivity is because we were managing it in the way we are discussing. Because of the court decisions, we are now having to manage the program under 5 different scenarios. So if you are driving, if you've entered the program and you had 3 or more convictions of driving under the influence of alcohol, and you are now driving under the influence of drugs, we would put you back into your original condition. With the court decisions, I can't.
Okay.
Because you're not violating alcohol, for example, in the original of 1990.
So, okay, I understand the concern that you're trying to address. But is it not possible? I think, Senator Chittenden's question is the same as mine. If you're, regardless of which condition you came into in the past, it seems to me what you're saying, effective when we modify this, everybody is going to be subject, their conditions are going to be replaced with this new set of conditions from this day forward. So the retroactivity in some ways is saying just because you came in under those conditions doesn't mean that they continue unchanged forever. That we're going to, by passage of this, say, regardless of the law in effect, when you came into the program, as of, say, July 1st, these are the new conditions. We're notifying them of the new conditions. And if they violate, then they are then you take action. And we only have the one set of rules that exist whenever we make this effective. That's what it seems to me it's clearer in my mind to say, we don't care with the rules in the past. They've been modified over the years. People came in different times. So what we're saying is, we're notifying you, these are the rules now, and you will be subject to them. And from this point forward. So maybe it's the way it's being expressed, but that's how I understand it. And that's how I think you're responding to Senator Chittenden. And I'm sorry to,
No, that's fine.
And that gets rid of that, it deals with the court decision to say you got to manage to 5 different sets of rules depending on the statutory requirements at the point of entry into the program. So to me, it's clearer to say prospectively, as of this date, these are the rules, they apply to everybody, regardless of when you came in. And if you violate them, then this is what's going to happen.
Agree.
So maybe it's just the way it's being expressed. It's the retroactivity. But I think what you're really trying to do is say these new rules will be applied to anyone who is already in the program. And that way it is retroactive. I don't see it as retroactive. We aren't going back and changing the rules that were in place in 1994 or whatever it was. What we're doing is saying we're changing the rules, we're changing them effectively, and everybody is now subject to those rules.
Anthea, are you on with us this morning?
I am.
Do you understand what we're
suggestions?
struggling with, Anthea?
So Senator Kitchell, I think what you're saying is you want it to apply as of the date of passage or whatever you determine is the effective date, and you want it to apply for that point going forward. And I'm not going to use the retroactive word, but
Right.
you want that prospective applicability to apply back in the future to everyone that's already in the program from that point going forward.
Yeah.
I think we can describe that without using the word retroactive. I think we need to change the effective dates language and maybe the
Yeah.
notice requirement. But I can definitely work with Commissioner Manoli on some language that I think does that and make sure that the committee is comfortable with that.
You know,
How's that sound?
it sounds fine to me. It just makes it clearer that
Okay.
these are the new rules. You're all subject to it. I don't care how
And,
many.
Can we?
I'm sorry.
Yes, go right ahead. Senator Chittenden, you had your hand up again? Yep. Oh,
Good, thank you.
can we agree on some language that we can work on,
Yeah.
Wanda, or how?
Absolutely. And I will just, say to the committee, using the word retroactive, I know, and I really appreciate the comments that Senator Kitchell and the questioning, because I do think I understand how that can bring confusion. And I'm happy to work with Anthea on this. So we can accomplish it without creating more confusion with that
Okay.
definition.
Can we move on to other parts of this bill so then we can get back to this one? Is that all right with everybody?
Well,
Yes.
if there's agreement, I like the way we can express it.
Okay,
And
as long
I
as,
think Anthea was capturing really what Senator Chittenden and I were
so if we
struggling
give them
with.
the opportunity today, Anthea and Wanda, to work out some language. But meanwhile, to keep this discussion going, can we continue on the bill?
Yeah, sure.
Other parts of it? Okay, all right, thank you.
So, thank you. Moving right along, the next section that you wanted some general, you had a couple of questions on is on the overweight permits and the change to the fees that we have proposed. And if I can just turn it over to Captain Andrews, he's going to give you the very quick and efficient definition of what we are trying to accomplish here.
Sure,
Captain,
thank you.
just don't use the word retroactive, okay?
Please don't.
I'll keep that out. I'll keep that out.
Okay, thank you.
Good morning, committee. My name is Kevin Andrews. I'm a captain with the Enforcement Safety Division here at DMV. And what we're proposing is some statutory changes in Title 23, Section 1392 to streamline our business practices while keeping it equitable for the industry regarding the transportation of unprocessed milk products. So currently in statute, there are 3 ways for a company to legally haul 90,000 pounds of unprocessed milk products. The first way is to register for 80,000 pounds and purchase a $382 excess weight permit that gives you the privilege of operating to 90,000 pounds with unprocessed milk products. The second way is to register to 90,000 pounds and purchase an additional $10 excess weight permit that allows you to operate at 90,000 pounds on the interstate highway system. And then the third way is to register for 80,000 pounds and purchase a 90,000 pound all products permit for $415, which entitles you to haul any commodity at 90,000 pounds. So in order to streamline our practices, what we are proposing is to eliminate the $10 permit required by statute to haul 90,000 pounds on the interstate. At this point, with the changes in the federal rules, that's just an unnecessary burden to the industry and is basically could be obsolete at this point. The second proposal is that we eliminate the $382 permit to register for 80,000 pounds and haul 90,000 pounds of unprocessed milk products only. And what we're proposing to do is replace the needs that permit fulfills with just the all products permit. However, to make it equitable, we're proposing that we reduce the fee from $415 down to $382, which is the price of the current excess weight permit for unprocessed milk.
Any questions so far?
The milk haulers are fine. Nobody, this would be a little easier for them, I suspect.
It will be easier for all industry, yes.
Okay, anytime we can simplify things, I certainly in favor of that.
Right.
You can, it just doesn't
Absolutely.
matter. There's only a couple dollars difference one way or the other, so it's not going to affect them financially. So,
Correct.
any
It will be a
questions?
savings to them.
Right, right.
It will be a
Senator-
savings to the industry.
Senator Chittenden, you had your hand? Yep.
On that same vein of reasoning or questioning, Chair Mazza, so who is calling for this? Is this just the DMV wanting to simplify things? Have the milk haulers reached out asking for this? What motivated this change, if I may ask?
So every year the miscellaneous bill, we look at statutes where we maybe aren't in alignment or we need clarification. And as Captain Andrews said, the federal permitting requirements were changed, and we are aligning Vermont statute with those requirements. And this is a positive for the agricultural industry. Absolutely.
I don't see any major, I think it's just more of a correction to make things simpler. So anybody else have any comments, thoughts? Can we write this off or?
Yeah, let's close
Okay,
it.
okay, close it off. Good.
So
Okay.
the next section of the miscellaneous bill, section 5, is we've proposed modification to the title 23-2020, which is to allow Vermont residents to obtain a certificate of title vis-a-vis title bonds, and to eliminate this from process to non-residents. And Mike can give you, he knows the history about this, but it's important to allow our residents to have access to this, but we are trying to stop other individuals from out of state getting title to cars that we don't register and we're not responsible for.
Good morning, everybody. Michael Smith, Deputy Commissioner for DMV. And Commissioner Manoli really hit the nail on the head. Vermont and all states, for that matter, have a process for individuals who have obtained a vehicle that do not have the ownership document for it. In Vermont, our statutes require that you purchase a bond for 1.5 times the value of the vehicle, and you must maintain that bond for 3 full years. And that is put in place so that if a lien holder came forward and said money's owed on that car, or Captain Andrews showed up and said that's my car and I need ownership, then he would be paid for it through that bond. What we find is that the states around us have much the same law, but their requirements are a little bit more strict. Most other states are asking for a bond in anywhere from 2 to 3 times the amount, and they require it to be held for 5 years. So what we find is a lot of non-residents seeking a faster way to move through this process and the least expensive come to Vermont to do it. So what we're really trying to do is say this is a special process. We have it, all the other states do, and this should be tailored towards Vermont residents only. The other issue that we find is when you're trying to secure the bond and verify the bond, when you're dealing with those from outside of Vermont, it's a little bit more problematic. So this really just brings this law into alignment, much like we did with the exempt titles years ago, where it's available for Vermont residents.
And I would just add to Deputy Smith's comments is that, we don't want to be the state. We want individuals to comply with their jurisdictional law. So if you live in New Hampshire, we want you to comply with New Hampshire DMV law and not use Vermont as your alternate to get around what their requirement is.
Questions, Senator Pertwee?
Yeah, Commissioner, did the DMV get some pushback from other states on this issue? Like, I know this was something that people knew about in other states, and I didn't know if you're bringing this forward because of attention and complaints from other states, or what was the cause to bring this forward now?
So
It was your proposal.
it's a little bit of yes. So, I mean, we have had some commentary from the other states, and we're also seeing that a lot of the individuals, some of the individuals applying for these have no ties to Vermont at all. So that's why it came forward.
But it's been that way for many, many years, right?
Correct.
Hello, Mike, you said this was not related to other people getting titles that was in the newspaper coverage about Vermont being one of the few states to issue titles.
Right. So the stuff that was in the newspapers was in regards to individuals coming here from other states and registering, and in some case, titling vehicles that were not allowed to be titled in their home jurisdiction. Those are generally not individuals coming forward under the bonding side,
Okay.
but they could be. So.
Question? Jennifer, go ahead.
So on that, Mike, I know one thing that I've heard about is people that are doing all the vans and buses renovations, and often they don't have title, like an old school bus or something like that. So which I'm assuming you wouldn't need the bonding for. But so somebody in New Hampshire that has an old school bus, could they still title that in Vermont, or that's also prohibited under this change, or is it prohibited just from something else?
So if it's over 15 years, Vermont does not produce a title. The only way to get a title after 15 years would be under the exempt title procedures. And in order to do that, you have to be a Vermont resident. So if you lived in New Hampshire and you had a school bus that's a 1992 and you wanted to register that in Vermont, we would allow you to register that. We would not title it for you.
Right. Okay. Thank you.
You're welcome.
Any other
So
questions?
moving,
Yep,
Can we close that then?
yep. Everybody all right with it? I don't see any. I think it's okay. All right, we close that. Go ahead.
so the next section of the miscellaneous bill that we're proposing a change to is under the purchase and use tax. This is section 6, and this is really eliminating the 3-year requirement of ownership to qualify for purchase and use tax exemptions. And what we experienced during COVID, well, we're still in COVID, but at the onset of COVID, as we had new residents moving to Vermont and registering their vehicles, the way the current statute is written, they were not eligible for us to take their credit, the tax credit in which the state they had paid taxes. And this language is really to bring clarification to that.
Yes, we're a little out of order though. That's
Oh,
number 7.
I'm number 7. Sorry. Well, thank you.
Sorry. So
Well, that's number 7. So do 6 and 7.
okay, so number 6, this is in regards to purchase and use tax. Many years ago, you were only able to register and title vehicles in the state of Vermont. It had to happen at the same time. So after that, we created, or you created, for the very way to say it, an ability for individuals to title only. Okay, so now you can title a vehicle or you can register and title a vehicle. The statutes in regards to trade-in credits said that if you were going to receive a tax credit, that vehicle had to be registered to you. Now, the change in the statute, when you authorize title onlys, you're still subject to purchase and use tax. When you register and title, you're subject to purchase and use tax. So our contention is that when you go to trade that vehicle in, regardless of whether it's been registered and titled or just titled, purchase and use tax has been paid on that vehicle, and it should be allowed as a trade-in because you've paid those taxes on the vehicle. So what we're trying to do is align statute with what we believe was the intent of the legislature when the titling law was created.
So it gives you the credit on the, towards the new, or the difference.
Correct, and only in situations where you've paid the tax.
Right. Yeah.
Correct.
Now, the out-of-stater that you just mentioned, when they're coming in from another state, they have to pay the purchase and use on the full value of that car if we're not giving them credit, right?
So basically, when you move in from out of state, we look at your vehicle and we assess a value to it. and
Okay.
times it by 6% and say, here's the tax. And then we look at you and say, do you have proof of tax paid from another state? So we're kind of jumping into 7 here, but
Okay.
at that point in time, if they do have proof of taxes paid from the other state, we'll credit them for it. If they don't, sliding into number 7 now, if they could provide proof to us that they had it registered and titled to them in the other jurisdiction for 3 full years, we would give them the credit. The
I see.
problem is, and it's the same here in Vermont, we issue 1-year and 2-year registrations. So when you show up, you don't have a 3-year registration. So what we end up with is we charge these people, the new customers, new residents tax, they leave a little unhappy, then they later send in their proof of tax paid and we end up refunding it. So what we're trying to say is if an individual shows up in Vermont to transfer to Vermont and they have proof that they're registered in a jurisdiction that charges tax,
Right.
that's enough
Yeah.
because we know they paid it.
That's fairness. Yeah. Yeah.
Mm.
Questions
Yes,
on,
exactly.
questions on 6? Yes, Senator Perchlik.
Thank you. Real quick on that, the language that you're striking in F at the top of page 18 that talks about 1995, that's what's prohibiting.
Yes.
Well, I guess why is it 1995? That's just the year that it happened. So they set it at that date and it's just carried forward ever since.
So that's another section that's included in this portion of the bill. And what that talks about is when the legislature made the change in regards to leased vehicles. Because it used to be many, many moons ago when I started here, if you leased a vehicle, you paid full tax on that vehicle. If you then bought that car, you paid full tax on that vehicle. Because when you leased it, it wasn't yours. You paid the tax in the name of the leasing company. So what the legislature did is they recognized that fact. And in 1995, they changed the law so that when you initially register a leased vehicle, you pay based on acquisition minus lease end value. So basically you pay half the tax. If you then decide to purchase that vehicle, then you pay the other half. So we get full tax on the vehicle. And this section that's being pulled out is something that was caught by Ledge Council. And that section that refers to 1995 dealt with leases that were in effect when that law became effective. So there's no leases that are 26 years old, so there's no sense in having it in statute anymore.
Okay, I get it. Thank you.
You're welcome.
How are we coming? Questions? We're in agreement? Okay, we can close that off.
That is the end of the DMV miscellaneous bill
Okay.
proposals.
What I'd like now is it's 11 o'clock. Is there any chance that Anthea and you could get together and come back with some language by 11:30, for example? And so,
I am available for Anthea.
I
Okay,
just
just-
emailed you something.
so maybe we could, or we want to review it and take some time to look at it, or how you want to do this? Because I'd rather wrap this up this morning if I could.
But
Okay.
what about consideration of that abandoned vehicle statutory clarification? I
Well, that's,
thought
we're taking that up tomorrow.
Well, won't it be
we-
too late then to make it part of the DMV bill? We voted out today. Are you talking about
Well,
voting
yeah,
it
but
out today?
We're also talking about abandoned vehicle. We're talking about towing too. It's in the same discussion, right? Am I hearing that correct? This is it's a subject that it says abandoned vehicles, but it's also the towing problem that we're going to
We
take
don't
up.
have do we have a bill that we can do this on?
Well,
Because
what's
if
your
we,
wishes? I mean, I just don't know how much time we're going to have. We got to get this week, I'm told. And is this abandoned vehicles and towing going to take a considerable amount of time? Or I know it's on our agenda for 9 o'clock tomorrow morning, but can this still be added at that time, or how are we going to work this?
yeah, well, we have until Friday, right, to vote it out. Is that right, Anthea?
You have until Friday to introduce it. So
Yeah.
I
I
know
mean-
that our office was talking to Secretary Bloomer to figure out if it could be a Friday morning thing, but you definitely have some time.
Okay,
And I am not in the loop on this abandoned vehicles issue. So if that is
Okay.
something the committee wants to proceed with, I'm going to need some guidance on what language needs to be written.
okay.
Well, Wanda, are you still there?
Yes.
Oh yeah, you are. I see all three of you. I'm looking for you, just your views. This was an issue that was brought to your attention this summer. I think Senator Ingalls brought it, and there was some question about the clarity of the statute. You were going to research it. And so if it needed some modification, this seemed to be the vehicle to do it. So do you remember that exchange and the situation? And so this is just an opportunity to bring us up to date. Is there a need for statutory?
Are we gonna do just abandoned vehicles, or are we gonna do towing?
I don't know.
Well, that's the issue,
one mi-
because Jeanette White was concerned about towing, and it's
Yeah.
been, so we gotta discuss whether
Yeah,
we're going
I
one or
think-
two.
Right, and almost can't discuss it until we hear what they say tomorrow, right? I mean,
Okay,
if they're
so
coming
we-
into,
So why don't we wait till tomorrow and try to resolve this other part of this bill this morning? I'd like to get this one here, this section all wrapped up.
Yeah,
if we
that's
could.
fine.
So let's
But-
take a break until,
Senator
how long do you
Moss,
need? Yes,
I just want to point out that the testimony on abandoned vehicles and towing is not at 9 o'clock tomorrow morning. It isn't until 11:15.
okay.
But it's
that's
tomorrow
okay.
morning.
is that gonna allow us enough time?
So would we switch, Jeannie, what's on at 9?
And Thea, well, we were going to do the possible vote on the miscellaneous bill.
Oh,
That's what it was going to be. So now it's all shifting around again. So we don't have any, if you do the vote today, we don't have anything at 9 o'clock, but I don't know if I can move the witnesses to 9 o'clock.
I can
so-
get them for 9 o'clock if that's what's gonna work best for the committee.
It
Yep.
seems like we can move this bill. If in fact these two issues are bigger than we can do in the DMV bill, we can decide that after
Yeah.
testimony and move
Right.
this bill out very quickly. And my question back to Wanda, do you remember that exchange? And is that something you could be prepared to speak to tomorrow morning?
So I do recall the exchange. Mike and I have looked at the language, and we are prepared to discuss the process around abandoned vehicles and to talk about the proposal on the 30 to 90 days for towing.
Okay.
okay, so we'll leave it on tomorrow morning at 9 o'clock. That's what I'm hearing.
Well, we have it for 11:15 as it is right now, Senator Mazza.
Well, I'm looking at the wrong agenda, I guess. I didn't get the updated one. Okay, 11:15, public transit budget.
No, that's an old agenda, Senator. There's been a number of changes, but you should have the new one in your email.
Okay, I probably got it. The other thing.
So Senator Ingalls, do you think you can get them for 9?
I think I can. I mean,
Okay.
I certainly enough time to where we can massage the agenda until then. I'll reach out to him right now if that's the favor of what Senator Mazza would like to have.
Another option,
Yeah, go ahead.
if Anthea could do the recommendation change to franchise at 9, then they could come after that.
Were we going to do that in the miscellaneous?
I don't think we're gonna have time to do that by Friday.
It's very, very, very complicated.
Yeah, that's what I'm thinking.
You also cannot do it with just hearing from me. You need to hear from many, many other people.
Yeah.
I think we should just deputize Anthea to figure it all out. and do it.
Yeah, that's right.
Please, please don't.
Yeah. Well, let's get back to today. And can we wrap up this bill this morning? That's my question.
So Senator, I need about probably a 3 or 4 minute conversation with Anthea, and then I think we're good to go.
Okay, so we want to come back in 15 minutes. Does that sound right?
Yeah,
Okay, let's reconvene in 15 minutes. Is
okay.
that all right, Jane?
Thank you.
Hey, I'm stopping live stream now, okay?
Okay,